Hello, I'm attorney Michael Einhauser, and I'm glad you could join me for this webinar. I'm going to answer some important questions that you might have about estate planning. First, let me tell you a little bit about myself. It's been my privilege to have provided estate planning services in Southeast Michigan for the past 25 years. In that time, I've assisted over 1,500 families achieve the peace of mind that an estate plan can provide. You know, I've always considered the practice of law one of the helping professions. Much like a physician or a pastor or a teacher, an estate planning lawyer should be a trusted professional that you can turn to for help with important but highly personal matters. Here are some common but important questions I get asked. In 2015, a Harris poll found that 64% of all American adults don't even have a simple will. And if you don't write a will, the state of Michigan will do it for you. And sometimes it might not be consistent with your wishes. You know, there's an old saying, people don't plan to fail, but many fail to plan. Why? Well, often it's simply procrastination. They just haven't gotten around to it. The other reason is lack of knowledge. Well, congratulations. By participating in this webinar, you've overcome any procrastination. And in the next 30 minutes or so, we'll give you the information you need to make important decisions about estate planning for you and your family. Let's begin with the understanding that an estate plan is not a commodity. It's the result of a process that involves careful deliberation on your part and experienced advice from your attorney. And that's why who you choose to be your attorney is so important. We begin with an initial consultation. People ask me, what should I bring to the initial consultation? That's easy. Just bring your questions. At my firm, I provide a free initial consultation. The law appropriately refers to the status between an attorney and his client as a relationship. And I believe it's important that both you and I agree we are an appropriate fit before you are asked to commit to any fees. I begin by asking questions about you, your family, your employment, and your general financial situation. And then I ask, what's important about estate planning for you? Here are some common concerns my clients have raised over the years. First, you want to make sure that your money goes to the people you choose. And often, it's just as important to make sure that certain people don't get your money. Second, you want to control when people get your money. Sometimes giving someone a lot of money is simply not in their best interests. Sometimes they may be too young, or dealing with challenges like addictions, or irresponsible with money. Sometimes they're hanging out with people who are a very bad influence. You may not want to disinherit them, but you do want to put controls on when and how they receive their inheritance. Third, you want to maintain as much control over your assets if you become disabled. Fourth, you want your estate to be settled promptly and not dragged out by unnecessary delays. Fifth, you want to ensure that your family's privacy is protected. You don't want details of your finances and health as part of any public court records. Let's start by asking the question, what's an estate? And it's a mistake to think that only rich people have an estate. Think about everything you own or control. Certainly there's your real estate, your home and any vacation property. There are your cars, the balances of your bank accounts, and any investments like stocks and bonds. And then there's your personal property, like jewelry, art, collectibles, and the like. And these days, a significant part of most people's estate are the retirement accounts, IRAs, 401ks, other tax-deferred accounts like annuities. Oh, and don't forget life insurance. Though the insurance benefits go directly to the people you name as a beneficiary, the IRS counts life insurance as part of your estate for purposes of calculating estate taxes. You know, I found that when people total it all up, they are often surprised at exactly how much they actually have. Now, once we've understood the concept of an estate, we have to think about how you can have full control over your assets. How do we conduct transactions regarding our assets? Usually with a signature. We sign checks, we sign deeds, we sign stock powers, and various kinds of authorizations for our property. But what happens if we are no longer able to sign such documents because we're disabled or because we've passed away? Without a plan, your family will have to go to the probate court. Now, there are two kinds of probate, what I call living probate and death probate. Should the time come that you can neither physically nor mentally be able to handle your affairs, someone will have to petition the probate court to appoint a conservator or a guardian to manage your affairs. This is what I call living probate. And there are three huge problems with living probate. Number one, it's a public court proceeding. The judge will appoint an independent attorney to serve as guardian ad litem. This is a temporary guardian for your loved one. He or she will visit your loved one, talk to medical personnel, and write a detailed report to the court to verify that you've told the truth in your petition. No one wants the details of their health or family relationships part of the public record where they can be seen by literally anyone. Number two, it's a waste of time. The process of petitioning the appointment of a conservator or a guardian can take months to complete. And the final decision is made by the probate judge, not by you. Third, it's very expensive. The family has to pay for its own lawyer's fees and the fee charged by the guardian ad litem, and has to pay the court filing fees. Pretty much the same thing can be said about death probate. Even if you have a will, your family will have to open a probate estate. The judge will appoint a personal representative who has the authority to carry out the directions in your will. And like living probate, death probate is, number one, open to the public. Your family will spend a lot of money filing all kinds of documents in court and do other things that you can simply avoid by planning ahead. Your private information becomes public, and anyone can see how much you are leaving to your family. Now, I think this is nobody's business other than you and your family members. Number two, death probate is a waste of time. Probate often lasts more than 14 months. Can you imagine your family going to court for more than a year just to get their hands on everything that you left them? And third, death probate is expensive. There are filing fees, an inventory fee, which is a percentage of your total assets, and of course, attorney fees. Your family could be spending tens of thousands of dollars in court before they inherit anything. There's got to be a better way, right? And of course there is. As an estate planning attorney, my mission in life is to put the probate court out of business. As noble a goal as that may be, I'm not likely to see it in my lifetime. As I said earlier, 64% of the adult population has done absolutely no estate planning. You need to be part of the 36% that makes sure you stay in control and have your wishes respected and implemented. The process starts with a careful consultation with you. We identify your specific preferences regarding what should happen if you are disabled and what should happen after your death. Then we create a set of legal documents that express your desires and contain express instructions to the people you choose to implement those desires. The centerpiece of your estate plan is a revocable living trust. To understand how a living trust operates, I suggest you think of it as a box. It's a box where you put all of your assets. Right now, you probably own all of your assets in your own name or jointly with your spouse. But when we create a living trust, we will transfer title of all of your assets to the trust. When we are done, what will you own in your own name? Nothing. And that's how we put the probate court out of business. Some of you are thinking, are you asking me to give up control over my money and my property? Absolutely not. When you create your living trust, you are 100% in control of everything while you're still healthy. And in your trust, you can name people to take care of your assets when you're gone. You can use your trust to make sure only people you trust can handle your assets for you. And remember, this is a revocable trust. You or your spouse can change your mind on anything while you're still healthy. And owning assets in your living trust does not change the way you do your taxes while you're alive. Finally, your trust will tell your family exactly who gets what. For example, you can leave your home to your son and perhaps your cash to your daughter. You can also use your trust to leave special instructions on who can manage your finances if you become disabled. If you do this, you will avoid the need to go to living probate. Your private affairs will remain private, and you can avoid the delay and the expense of going to court. And in the event of your death, again, your trust has special instructions in which you appoint someone who you trust to carry out your wishes. Here's another important feature of a living trust. Remember, at the beginning of this webinar, we saw that it's important for certain people, such as adult children, to receive your assets. But sometimes it's just as important that certain people can't get their hands on them. Sometimes parents are estranged from their children. Sometimes children may be irresponsible because of an addiction or may have made a bad marriage. The living trust is a powerful tool for you to control who gets your money, who doesn't get your money, or when it's appropriate for someone to get money. Let's talk about another important part of your estate plan. That's your healthcare power of attorney. Sometimes it's referred to as an advanced healthcare directive. With this document, you choose who you want to act as your patient advocate. You give one or more people who you trust the power to make important health decisions for you if the time should ever come that you cannot make those decisions yourself. You know, we've seen incredible advances in medical science. Doctors and other health professionals use modern devices and take heroic steps to keep us alive. But it's essential that you have someone who you know and trust acting as your medical advocate. They are there to direct the doctors to continue aggressive treatment, but they are also there to say, that's enough. It's time to let mom or dad go. Another important part of your estate plan is the pour-over will. This is an important backup document if something was left out of your trust. It also serves to revoke any prior wills you may have and will be used to name guardians if you have any minor children. We will also execute a property power of attorney that allows the person you appoint to be able to manage legal and financial matters outside of the trust. We'll also review beneficiary designations that you've made on any life insurance policies, annuities, and retirement plans, such as 401ks with your employer, or traditional or Roth IRAs. You know, there are very significant tax consequences to consider when distributions from tax-deferred retirement accounts occur. We will review who are the most appropriate beneficiaries and the most tax-efficient timing for making distributions from these accounts. You know, I found that there are two reasons people don't complete an estate plan. The first is that they don't have sufficient knowledge to move forward with planning. Well, you have overcome this by investing your time participating in this webinar. You now have the knowledge you need to make sensible and intelligent decisions about planning your estate. The second reason people don't complete an estate plan is good old-fashioned procrastination. Napoleon Hill said, "Procrastination is the bad habit of putting off until the day after tomorrow what should have been done the day before yesterday." Let's strike while the iron is hot, shall we? I invite you to schedule a 10-minute phone conversation with me. We will review the material we discussed in this webinar, answer any questions you may have, and determine whether or not to schedule an initial office consultation. It's that simple. And I'm going to go ahead and make it even easier and sweeter for two of you. Okay, listen up. The first two people who schedule a 10-minute phone call with me, I'm going to give them a 30% discount on their entire estate plan if we decide to work together. After this webinar, you're going to receive an email from me. Just follow the instructions in the email to claim this discount. I suggest you open your email right now. Well, I'm going to close with one of my favorite quotes. The writer Ralph Waldo Emerson said, "The only person you are destined to become is the person that you decide to be." So be someone who takes control of your life, your future, and your family's future. I'm attorney Michael Einhauser. I want to thank you for spending this time with me. I hope I have the pleasure of talking to you in the very near future.